Under section 75, the private documents. The private documents are those documents which are prepared between persons for their usual business transaction and communications. These documents are kept in the custody of the private persons only and are not made available to the public at large. The certified copies of a private documents are generally not considered as evidence unless there is a proof of the original copy is provided. Under section 76, certified copies of a public documents. This section provides the means of proof of public documents which any person has a right to inspect. There is a common law right of a person to take inspection of a document in which that person is interested for the protection of such interest. The person claiming interest in a specified land cannot be refused certified copies of the pahanis and fasal pattis on the ground that the land in question is classified in the revenue record as a government land. The section requires that a copy of a public document given by the public officer should bear a certificate written at the foot of such copy that it is true copy of such document. Where a copy bears no certificate and it is not supported by the evidence of the person who prepared it, it is not admissible in evidence. But a carbon copy of the court order issued in official process but not marked as a true copy was allowed in evidence. In a case of Jaswant Singh versus Gurudev Singh, 2012, 1 Supreme Court cases, 425, it was held that when a compromise becomes a part of a decree which is passed by the court, it is a public document in terms of section 74 of the Evidence Act. And certified copy of a public document prepared under section 76 of the Act is admissible in evidence without being proved by calling of witnesses. In a case of Tukaram S. Digole versus Manikrao Kokate, AIR 2008, NOC 1767, Bombay, it was held that an election petition alleged corrupt practice. It was alleged that the returned candidates had resorted to communal appeals. A certified copy of cassette of video recording of the speeches was alleged to have been obtained by the petitioner from the office of the Election Commission. Section 77, proof of documents by production of a certified copies. In reference to claim for a compensation before the Accident Claim Tribunal, Rajasthan High Court held that the tribunal has to follow the summary procedure without insisting upon the strict compliance of the provision of the Evidence Act. The court said that certified copies of the FIR, inspection map, site inspection memos, Panchnama, injury report or postmortem report and other relevant documents produced by the police officer or a doctor while discharging official duties should have been admitted in evidence without any formal proof. Even compromise become a part of the decree which is passed by the court. It is a public document in terms of section 74 of the Evidence Act. And certified copy of the public document prepared under section 76 of the Act is admissible in evidence under section 77 of the said Act. A certified copy of the public document is admissible in evidence without being proved by calling witnesses. Compensation claim for a land acquisition, comparable sales method was adopted for the working out the compensation amount. It was held that certified copy of a registered agreement of a sale was admissible without examining the parties of the document. It has been held that khasra, that is the revenue record, is a public document. A mere production of a copy of a record would be sufficient for its proof under section 77. But certificate given by the patwari, that is village record keeper, being a private document, it has to be proved by examining the patwari. A birth certificate issued by appropriate municipal authority is an ultimate document for a proof of a date of birth. It carries presumption as to its genuineness and is admissible in evidence. The presumption holds good unless rebutted. Different handwriting in a date of birth and the name of a child can be explained. That by itself does not make the record suspicious or fabricated. Under section 78, proof of other official documents. 78A, copies of a public document to be a good as original document in certain cases, notwithstanding anything contained in this act or any other law for the time being in force, where any public document concerning any area within the West Bengal have been kept in a Pakistan, then the copies of such public document shall, on being authenticated in such manner as may be prescribed from time to time by the state government by notification in the official gazette, be deemed to be have taken place and to be original document from which such copies were made, and all references to the original document shall be construed as including reference to such copies. For when original is a public document within the meaning of section 74, certified copy of a document but no other kind of secondary evidence is admissible. This section does not appear to have the effect of absolving the parties from any rule governing the proof of the fact on which they desire to rely. It is to be observed that the section does not say how any fact, historical or otherwise, is to be proved by the parties, but gives the court liberty to resort for its aid to appropriate books or documents of reference on a matter of public history. The proceeding of Parliament may be proved under clause 2 by the journals of the House of Commons or by copies of purporting to be printed by the order of the government. A carbon copy of the court order issued by official process but not marked as a true copy has been regarded as a good evidence. Cyclostyle copy of the type notification as a proof of particular forest being reserved one. In making an act authentication, the officer who makes it is to declare his authority to do so. Landlord refused to receive the money sent by tenant by money order. The post office issued a letter showing refusal. The letter is based on public record and therefore relevant. A copy of postmortem report can be received in evidence for the purpose of claim under the Motor Vehicle Act without calling the doctor. In case of Sr.Counsel Khemka versus Joharmal Manumul 50 Calcutta 549, it was held that Calcutta High Court has held that the court is not bound to have recourse exclusively to the mode of proof in respect of the public document set out in this section. This is a permissive and not an exclusive section. In a case of Govindas versus Rupkishore 4 Lahore 367, it was held that Lahore High Court has on other hand held that the text published in a gazette must be taken to be the authorized text of the Limitation Act of 1963 under clause 2 of this section. In a case of Lakshmiraj Setti versus State of Tamil Nadu, AIR 1988, Supreme Court 1274, it was held that the newspaper are not documents within the meaning of this section. Hence, the privilege given by this section is not enjoyed by fact reported in the newspaper.